the first to know in Nsem-Pii TV.
For Enrada NHS Ebabeto Abonte say the Attorney General and Minister of Justice, Dr. Dominic Ayine, I withdraw all cases against the third accused person, Mildred Donko, in the ongoing Adu-Boahen's case, betray the former Director General of National Signal Bureau, FIA 49 million Ghana cedis theft. In fact, Madam Mildred Donko ever mu ever court as the third accused person in the ongoing trial. Na mu ever court and the lawyers no. Nsem-Pii and I just say Abutu mu edi aba. Na for before that no, say okakoti Nsem court so ever courtroom no. Na Nsem and the lawyers can say enti na yoku omo investigations omo yeye a omo de charges ahodo na bi egu the third accused person. Eso Mildred Donko isu na yetimi ehu se maame no onye involved in the 49 million Ghana cedis theft no e de be pa na omo pa kire Ghana for e kama akoye se one omo investigations omo ye as yoko no e kama akoye se one e ye shoddy e sounds so e rushed na e sounds so e poorly thought out as ensema te se lawyer CB e ka no e monten eno no na no munim se Madam Mildred Donko ye betimi ayusu no as a prosecution witness anase sen anti omo de sa charges no egu no so before no Nsema abofri court ni bi abane se maame no she had no hand in the 49 million tests de ato Adu-Boahen eso no. In fact courtroom ho ensem afi ho abapa yenye bre nti ensema achese ebofri ho so epie.
Well, so what I can tell you right now is that the second prosecution witness, Madam Edith Edumua, is currently in the witness box. But just before she mounted the witness box, there been some interesting development that took place in court. Yesterday, we got information that the Attorney General has filed a notice of withdrawal specifically to have the third accused person in the matter, Mildred Donko, discharged or in the matter. And when the case was called this morning, Deputy Attorney General Dr. Nsem-Pii indicated to the court that they have filed that particular motion and their intentions are clear. What they want the court to do is to discharge the third accused person in the matter. Lawyers of Adu-Boahen, his wife Angela J. Boatin, and of course the company led by Samuel Atachian, was of the considered view that if you look at the nature of the case before the court, there are some aspects of the charges that the third accused person is on with the other accused person, and so an oral withdrawal, oral way of asking the courts to say that we want to. In fact, one of the issues was that was the charge sheet going to be amended. Deputy Attorney General said yes, there were minor issues that they could amend. They will use the pen to cancel them and sign against them. Things that normally happen in court when you are amending something that is not too much or something that is not the a bulky nature. That was when Samuel Atachian indicated that no, they have to come formally, go and amend the charge sheet properly and come and file a fresh one. But the court made references to some statute and decided cases and authorities, and was of the considered view that the Constitution makes it clear what the Attorney General can do and what it should do. Once it has filed a case of this nature before the court, the Attorney General has that particular power to come at any point in time to inform the court that they are withdrawing the charges. Consequent to that, the objection from Samuel Atachian was dismissed or overruled, and the court has subsequently discharged Mildred Donko, who is the third accused person. And so what I can tell you right now is that Mildred Donko and then those who came to court to sympathize with her have all left the premises of the court. But as we speak, the second prosecution witness is in the box and giving testimony in relation to this very case.
All right. Murtala, you also told us this morning on GH Today that the National Service Authority case involving the former Director General and his deputy was going to be heard. What's the latest on that?
So in respect of that, the indication is that these two individuals who appear in court, they will appear separately But as I talk to you now from the premises of the law court complex, they have not arrived. But I can tell you that the Deputy Attorney General, state prosecutors, have also seen the Director of Public Prosecution, Mrs. Yvonne Atakra-Obisa, and some state attorneys, all of them here, just so in case that when the time comes and these persons are to be arraigned, they will have that. My checks indicate that Gifty or Warimensan will be put before the criminal court 4, and of course, Osei-Sibe entry will be before the criminal court 5. But as we speak, they have not made an appearance here. But of course, the court closed at 4. By that time, we'll have more information as to whether they would really appear in court today, what really will be their response to their charges, and what will be the further direction from the courts that they will be appearing before.
Thank you.
Today, lawyers for Kwabena Adu-Boahen had made certain applications before the court. They were asking for certain documents, certain disclosures that they believe will help them make their case. The judge in this matter, Justice Nyante, had denied them that application and denied them those disclosures. And they decided that they were going to file an appeal at the Court of Appeal to challenge the decision by the trial High Court. For which reason, they came back to the High Court and asked for a stay of proceedings, which simply means that they wanted a trial to be put on hold pending the determination of the matters that they've taken to the Court of Appeal. Today, Justice Nyante reasoned that there's no reason to put on hold this trial while that appeal subsists at the Court of Appeal, and therefore dismiss same, which has meant that that trial is expected to continue. And in fact, prior to today taking about 1 hour break, the case was continuing, and the state had called this next prosecution witness and asked them several questions before the proceedings were put on hold for 1 hour. So the application by lawyers for Kwabena Adu-Boahen, led by Samuel Atachia, to put the entire trial on hold has been dismissed.
So the AG made a formal announcement today in court, specifically on the withdrawal of the charges against the third accused.
Yes, MFA, we know that yesterday we saw some court documents that purported to show that the Attorney General was dropping charges against one Mildred Donko. He's the third accused person in the case the state has built against Kwabena Adu-Boahen. Today, the AG formally informed the court of this decision that they have taken to drop charges against Mildred Donko, who we know now has become a prosecution witness and will be called at some point to testify in favor of the state. While Justice Nsem-Pii, the Deputy Attorney General, was on his feet addressing the court formally on the decision to drop the charges against Mildred Donko, Samuel Atachia, lawyer for Kwabena Adu-Boahen, stood up and had an objection. His objection was that the dropping of the charges against Mildred Donko should have come by way of motion and not by notice of discontinuance, because in his view, the motion will give the judge an opportunity to make a determination as to whether or not the charges must be dropped. But the Deputy AG shot back. In the view of Justice Nsem-Pii, the notice of discontinuance is the way to go, because the Attorney General has the prerogative to decide who to file charges against or who not to file charges against. And so any decision to come by way of motion, which will give the judge an opportunity to make a decision on the matter, will impinge on the Attorney General's discretion and his prerogative to file charges and dismiss him. Ultimately, again, the judge agreed with the state in this matter and overruled the objection raised by the lawyers for Kwabena Adu-Boahen, and the ruling was to the effect that the state was right to have come by way of a notice of discontinuance and not a motion. And so 2 objections and 2 applications today raised in favor of Kwabena Adu-Boahen, all of them dismissed by the courts.
It has considering legal action to stop Alan Chermanton's newly formed party from adopting the name United Party. Wale MP Tia Kabiru argues that the name choice is problematic and could mislead the public, given the NPP's historical roots in the United Party tradition. The minority MP accuses Alan Chermanton's team of attempting to hide under the flag of the UP tradition, potentially distorting political history. The Wale MP says the NPP will test the name's legitimacy in court, confident of that it has a strong case. Now let's engage the NPP, or the MP who has been speaking on this particular matter. First, you said the NPP is headed to court over the use of United Party. You say that you're considering. Tell me whether or not you have arrived at a finality or you have arrived at a final conclusion that you will pursue this. But if you do, what exactly will give the party the legal or moral claim to this name?
I am only a member of the New Patriotic Party who has been elected on the ticket of the New Patriotic Party to represent the good people of Wale Wale as their lawmaker. And the laws of this country are sacred, and that if there's any potential breach of any law, there's a need to bring finality and clarity to that particular matter so that everyone will be at it. The government of my case is that the United Party was a political party formed on the 13th of October 1957. That party was dissolved following the passage of a law by the National Assembly to make Ghana a one-party state. But the history of the now New Patriotic Party, which was formed somewhere in July 1992, was actually having its roots. It's taking this root from the United Party, led by Abutu, K.A. Buja. So one cannot understand why in October 2025, Mr. Nsem-Pii is forming a political party and using the name of a political party which the NPP tradition is derived from. You are basically robbing the New Patriotic Parties of its heritage if we allow the name to stand. And though the Section 10 of the Political Parties Act clearly prohibits the use of a name that is likely to send confusion in the minds of people, I wonder why the Electoral Commission went ahead to still give them the provisional certificate to offer it. Nonetheless, I admit that it's a provisional certificate, and then subject to any petition, they are bound to review their decision.
And so when you head to court finally, you're going to be asking, under which particular law would you be triggering this?
I have just made provision or reference to the Political Parties Act, which is the laws of the country, which is about the naming or taking names that are similar or that are likely to bring confusion in the minds of people as to which political party you are referring to. That is one. I mean, they could also come in civil action. You understand that people, lawyers, will probably guide and advise that this is a typical case of past law. An act intending to take the name, the businesses and customer of a particular company, if we consider political party in the light of corporate entities incorporated for that matter. So these are possible avenues, and of course, if advised by counsel, and they would be very much clinical with the laws. But I believe that this particular name is in breach of Section 10 of the Political Parties Act. I believe that it amounts to passing off, and there are laws on trademark infringement in the country that are supposed to help us resolve the matter.
In an attempt, would you as well be taking on the Electoral Commission, because at least they saw that law and still issued and allowed them to use that name?
Well, I understand that the certificate issue is temporary. It's not a binding, it's not a final certificate. We've had political parties, EC issue provisional certificates to political parties which have not seen the light of day at the end of the day. So you not fault them. It's also based on their careful look at the law. They also understand that they don't have the right to the interpretation of the law, and that what they ordinarily look at is what they are going to apply. And someone brings the matter to their attention and they investigate, or they still deny, the person proceeds to court and then determine the legal rights thereof. I'm sure the EC would oblige. So I don't have issue with the Electoral Commission.
Okay.
But there is a political party that has been formed that my issues are directed.
I mean, I hear you give a bit of history and background to this particular matter, but particularly, are you concerned more about the brand protection or historical preservation?
It is the historical preservation of the New Patriotic Party that is at stake here. And it's not about the praises behind the party. I have no issue. They came under movement for change. We all saw their performance. I don't think that nothing significant would change if they are even a political party properly incorporated or properly established. So my only issue is to the fact that you cannot sit down and allow someone rob the history of the New Patriotic, now New Patriotic Party, and to deny us of our historical antecedents and how we have come to be called the New Patriotic Party today. We make reference to the UGCC. We make reference to the Popular Front Party. We make reference to the Northern People's Party. We make reference to the National Liberation Movement. because they are part and parcel of the history of the New Patriotic Party.
What then would you say to people who say that this appears like the NPP? If not, I mean, you have said that it's not the party in general, it is you, but people, of course, will impute this as well into the party. That it makes the NPP appear quite threatened by the Alan Chairman's new movement. And how do you respond to this perception?
Right, I mean, it's just so far-fetched, and it is too remote for anyone to assume that a member of the New Patriotic Party raising issue. Mind you, members of the New Patriotic Party, they will raise issue against the New Patriotic Party. Why don't they interpret it to mean that the New Patriotic Party is raising issue against itself? If any member of the New Patriotic Party feels that there's a breach of a law and that there is some acquaintances, I mean, there are some people condoning with the, breach of the law, and that you are at liberty to do that and you have the wherewithal to do so, you proceed. And I don't want anyone interpreting it to mean the New Patriotic Party. In effect, I'm not in the New Patriotic Party. I'm only a right, and a member of Parliament, New Patriotic Party. I have not had I've not had support, the concurrence of the New Patriotic Party in this move. In fact, I'm yet to even consult the New Patriotic Party on these my personal views. But I think that these personal views are born out of my understanding of our history and my understanding of the potential breach to the laws of the country.
Which means that if the party doesn't support this move, you won't be heading to court.
I'm a member of the New Patriotic Party. If it is so realized that the party advisor, though it doesn't breach any law, so don't go, I would oblige. If the party so below, though there are potential breaches, but they are not so fatal, and that the integrity of the New Patriotic Party is at stake and that we should protect it, I will again oblige, because it is about the New Patriotic Party, and if the leadership of the New Patriotic Party thinks otherwise, I will oblige.